argument session of the 5th District Court of Appeal. Marshall identified me to my right. We've got Judge Orfinger from here in Volusia County to my left. Judge Edwards in Seminole or Orange? How do you?
Seminole.
Seminole, right, from Seminole County. We've got 3 cases on the docket this morning, and 2 of the 3 are criminal cases. Those will be given 15 minutes each. If you would like time for rebuttal, just let me know and I'll accommodate you for that. The last or 3rd case will be 20 minutes per side. Again, let me know what you would like for any time for rebuttal. If you have any electronic devices, anything that would make noise, just please put it on silent or turn it off so that you don't interrupt the arguments of the lawyers. So, with that said, Sandhaus versus State.
Good morning, Your Honors.
How much time would you like for rebuttal, Mr. Keogh?
Pardon?
How much time would you like for rebuttal?
3 minutes for rebuttal, Judge.
Okay.
Good morning, Your Honors. May it please the Court, I'm Terrence Keogh, appearing on behalf of the appellant Craig Sandhaus. Mr. Sandhaus was convicted at trial of murder in the 2nd degree and is serving a 45-year sentence. There are several issues.
I want to make sure that I understand the defense in the case. As I understand it, the defense was it wasn't me, but if it was me, it was self-defense. Is that accurate?
Well, those were both argued in closing, both of those. Throughout the trial, in voir dire and opening statement, they announced self-defense. The only defense that the jury was instructed on was self-defense. And in closing, they added, the video doesn't really show that this man did it. But self-defense was the primary defense throughout this case. So I'd like to start with the first issue.
Isn't that undercut, though, by the argument that it wasn't me? I mean, to claim self-defense, implicitly you have to say, it was me, but I was excused from doing it.
Well, I understand for self-defense that's what you have to claim, but a defendant is entitled to raise any defense that the evidence presents. In closing, after the state's case, the defense chose to say, you know what, the state's evidence didn't prove that this man committed it, and one of the essential elements, obviously, in a criminal case is they have to prove that this defendant committed the crime. But they said, essentially, that if you don't buy that, then the defense here is self-defense. It is the defense that's argued from the beginning of this case to the end. Contrary to the state's claim, it was never abandoned. It was absolutely asserted in closing argument. The state spent quite a bit of time trying to debunk the self-defense argument. So it was clearly the contention that his actions, Craig Sandhaus's actions, were proper on the night in question. I'd like to address the motion to dismiss issue, the stand your ground pretrial issue. We contend that the trial court erred in denying that motion on three separate reasons. The first, trial court erred in finding that there was no evidence that a forcible felony was being committed on Eric Sandhaus. I'll come back to each of these in a second. I just want to set out the 3. So, erred in the finding there was no forcible felony being committed on Eric. Erred in the finding that Craig Sandhaus was engaged in unlawful activity because he possessed a pocket knife, which the court erroneously found to be not a common pocket knife. And third, and most importantly, erred in the finding that Craig Sandhaus acted unreasonably in his level of force. Now, the court recognized that Craig Sandhaus could react in this situation to defend his brother. The court's problem was the level of reaction, because the court said essentially the level of reaction was too great, that he could have reacted with his hands instead of introducing the knife into this situation. But that's not the correct focus. It's not whether he could have reacted in a different way. It's was the way that he reacted unreasonable. Because in Mobley, when the guy uses a gun to kill two people after there's one punch thrown, one of the reasons that the trial court in Mobley denied it was they said that the defendant could have used a lesser level of force, either by brandishing the firearm or firing a warning shot or something. And the third
Wasn't there some
DCA
thought
said-
in Mobley, though, that the victim was going for a weapon?
Pardon me?
Wasn't there some thought that the victim in Mobley was going for a weapon?
One of the two, there was no weapon found, but there was some thought that the victim was going for a weapon.
Which we don't have here.
We don't have that here, but what we do have is Eric Sandhaus getting beaten seriously by at least two bouncers. This whole incident occurred in less than 25 seconds, okay? Mobley, we got a 12-second incident. Here we got a 25-second incident. We have, if you look
But
at
up
the...
until the time of the stabbing, though, I thought it was pretty well unrebutted. Up to the point of the stabbing, it's one-on-one.
No, clearly not. Campos, who was the only, Jose Campos, who was the only state witness to testify at the stand your ground hearing, and this is, of course, determined separately from the evidence at trial. The stand your ground hearing, the state only put Mr. Campos on, and he testified, he denied initially not even hitting Eric, but then he admitted he did. And if you look at the video, which is critical, it shows that Campos immediately hitting Eric. And the most important part is there's a point on the video where Eric has his shirt pulled over his head and tied. He's bent over completely, and there's two guys on him. Craig Sandhaus brings to this incident knowledge that his brother had bipolar condition with some mental health issues, and that he had
There was
medical
no, but those conditions being admitted, there was nothing about any of those in the record showing that he was especially vulnerable then, helpless, unable to defend himself any differently than any other person of his size and stature.
But in a self-defense, you have to, what does the defendant know about this situation?
That's what I'm asking you. What about being bipolar or having the surgeries or anything else made him vulnerable to attack?
Well, because he believed that his brother could not defend himself against these two people who were professional bouncers, so to speak, and his brother's not, and he's worried about these surgeries on his head.
But that was some time back, wasn't it? I mean, it's
It-
not like
it
he just
was-
had surgery and now he was at the bar.
It is unclear. It was clearly prior to this incident by years and not days or months, but it all goes into his knowledge and why he's reacting. He's reacting because he sees his brother, who he believes is vulnerable, and it's reasonable under these facts, what he knows about his brother, to believe his brother is vulnerable. But anybody seeing that two people beating on a third, and that's your brother, this is a forcible felony being committed on Eric Sandhaus by the two bouncers, all right?
What was the forcible felony?
Aggravated battery. The state agreed to that at trial by allowing that jury instruction on, I realize we're not at trial at the time of the hearing, but the forcible felony was aggravated battery because the bouncers are committing great bodily harm on Eric Sandhaus. Now, the thing about it is,
Did he suffer great bodily harm?
he had cuts and bruises. He had a cut. He was bleeding from his head.
If you were representing a client who had cuts and, who had inflicted cuts and bruises on a victim, you certainly wouldn't be suggesting that was aggravated battery.
If I'm defending the client, I'm certainly not suggesting it's aggravated battery, because I don't want my client convicted of aggravated battery. But first of all, this statute, you don't have to wait till the guy is beaten and suffers a broken bone. It's perceiving that imminent danger of this.
Under your theory, as soon as someone throws the first punch, that becomes an aggravated battery under that theory.
Well, in Mobley, there's only one punch thrown. All right?
That case seems to be somewhat of an outlier when you look at the whole range of cases that are out there. But let's talk about the statute. It says, you have a right to stand your ground and meet force with force, including deadly force. doesn't meet force with force suggest some level of proportionality? That, you know, if I throw a punch at you, you know, under normal circumstances, that doesn't justify you pulling out your gun and shooting me. It might certainly justify you punching me back or, you know, shoving me or something else, but doesn't meet force with force suggest that there's a need of proportionality even under that instruction?
No, because the statute says you can use deadly force if you believe one of these two situations. And in Hare and Mobley, the other person doesn't even have any weapon, and they're getting shot with a gun, okay, and killed. All right. Now I understand that people may not like this statute, but the statute says that if the victim is doing one of these two acts, and
No, the legislature loves the statute.
I understand that, Judge. I understand. But what I'm saying is, Hare, the person is retreating from the vehicle and gets shot and killed, and the court says that's fine. That's justifiable because he was committing a forcible felony.
Yeah, he jumped in the guy's car and started fighting with him.
Absolutely. But there's no evidence that he's, you know, beating him to death or anything like that. He has now retreated or trying to back out of the car, and he's shot.
Mr. Keough, I'd like you to take just you can make the call on this. If you want to continue and discuss the self-defense more, you're free to do that. But I'd like to hear a little of your discussion about whether there was sufficient evidence of ill will and spite.
That's fine, Judge. We submit that there's not sufficient evidence to convict of second-degree murder, and instead it should be reduced to manslaughter. And there's a line of cases all cited in the brief, essentially dealing with the idea of impulsive overreaction, that this is a short, quick incident. The key element of second-degree murder that we're contesting is the evidence of evil intent, malice, and that element. And one of the, although there are exceptions, one of the lines of thought in almost all of these cases is that the defendant didn't know the victim long enough to develop a sense of hatred or ill will or spite towards the victim. And the cases talk about that maybe the jury was correct in finding that the defendant overreacted and therefore didn't properly, or the defense of self-defense was properly rejected by the jury, but this should more likely be a manslaughter conviction instead of a second-degree murder conviction. So, Judge, you're right in that there's this line of cases out there. We believe that Mr. Sandhaus's case fits in that line of cases. That even if you reject every other argument, that this case should be reduced to a manslaughter.
You're into your rebuttal.
Just last second.
Sure.
Happened very, very quickly with a victim he didn't know. There was no prior animosity, and those cases should apply in this situation. I'd also believe that there are serious issues with the self-defense instruction, adding the voluntary intoxication when it was not a issue in the case, adding the definition of great bodily harm, which had nothing to do with the defendant's actions, which is where it was stuck in the jury instruction, and of course the Floyd issue, which was orally argued at the Supreme Court on November the 5th. Thank you.
All right, thank you.
Good morning, Your Honors, Counsel. May it please the Court. My name is Andrea Totten. I represent the people of the state of Florida. First, Your Honors, I'd like to discuss the idea that self-defense was actually a primary defense in this case because it is relevant to issue 3 and the self-defense jury instructions and the issues that most of which were unpreserved in the trial court that are now raised on appeal. To be sure, the issue of self-defense was hard-fought prior to trial with a motion to dismiss, stand your ground hearing. The state certainly proceeded at trial as though that was going to be the defense, understandably, based on the pretrial hearings. But when it came to closing arguments, there was virtually no mention of self-defense by appellant.
In the cross-examination of the witnesses, was the basis for potential self-defense discussed or raised?
Well, yes, I think that there was some thought in mind. I don't think that it was clear during the trial that self-defense had been abandoned at that point. I think it was a little bit of a surprise in closing arguments when almost the entirety of the argument focused on, actually, despite everything that you've just heard, it wasn't my client in any event.
What's said in closing arguments is an evidence, and so if it had been raised during the examination and cross-examination of witnesses, why isn't that sufficient?
Well, Your Honor, because of the argument that we're talking about fundamental error here, we're talking about unpreserved errors, and it wasn't a highlight of the defense, it wasn't the only defense, and that's one of the factors when you look at Floyd and some of the other cases that have come since Floyd. One of the factors that the courts have relied on is, for example, in Floyd, self-defense was the defendant's only defense. Whereas there's another case, it's a Florida Supreme Court case called Martinez, they pointed out that, yes, self-defense was one aspect, but he also had one or more other defenses, which is the case here, and that was something that they relied on in finding that there was no fundamental error on that basis. And here, again, in closing, the primary defense was, it wasn't appellant, it was Eric. In any event, the trial court was correct in denying the motion to dismiss. There was a 2-day hearing. The video was played for the trial judge repeatedly. The prosecutor presented the video through the defendant, but with still shots, second by second by second. Initially, the defendant and his brother said that, well, Eric was being beat up by 3 or 4 or 5 guys, and that's why I had to stab Mr. Torres. But then during the motion to dismiss hearing, the defendant admitted, okay, really it was just Eric and Torres. There was a movement by Campos that the state characterized and argued that the video showed Campos them trying to break up the fight between Torres and Eric. And the defendant said, well, I think that was him punching Eric. So there was a factual dispute about that the judge was required to resolve, and did resolve after hearing from numerous witnesses, including Campos, who denied having struck Eric up to that point. He admitted that, yeah, after the point that Mr. Torres got stabbed, I threw a couple of punches, and so did some other bouncers too. But he testified and denied that he had punched Eric before that. So at the time that defendant stabbed Mr. Torres, all that had occurred was an extremely brief fist fight between 2 men of comparable size and physical ability. Eric testified at the motion to dismiss hearing. He admitted that this surgery on his head for cysts had occurred years prior and that he suffered no physical disabilities as a result. There was testimony that he takes medication for a couple of mental health conditions, but he's obviously not incompetent. He has a job, as he testified, the same job as defendant. In fact, he had been on his own at other bars with other friends prior to this, so it's not that he's an invalid in need of defense like that. So the force was just not reasonable at the time. He stabbed to death a man who had been engaged in a fist fight with another man for a couple of seconds, and that's simply not reasonable. And the trial court had plenty of evidence to support its denial.
Every stabbing a second-degree murder?
No, I don't think that every stabbing is a second-degree.
So here, let's assume for the sake of discussion that you have an imperfect self-defense claim. I'm trying to understand what the evidence was of ill will, hatred, spite.
Sure. Well, first I would note the the standard of review that the trial court is employing, that it's taking the facts in the light most favorable to the state. If there's any way that a reasonable jury could view these facts and find second-degree murder, then it's appropriate to deny the motion for judgment of acquittal. Here you had several witnesses. You had Fred Traybold testified that as he was escorting defendant and his brother out, they're making statements like, "You're not throwing me out the back door." There was testimony that they were belligerent and loud. They kept trying to go back in. Torres became...
At a bar at 2 o'clock in the morning, that must be very unusual.
Well, at this point, I think they were outside, but you're right, at 2 o'clock in the morning at a downtown club, there was probably more than one belligerent and loud person, but...
They didn't know each other.
No.
And so the defendant comes to the aid of his brother who was involved in a fight, and assuming that we were to believe that the use of force was excessive in terms of self-defense, I'm still, what evidence is there of ill will and spite? We know that they're impaired, that they've been drinking, and I think that's what the police witnesses indicated. Mm-hmm. So you've got, a couple guys, who've been drinking all night at 10 to 2, getting kicked out of a bar, and then a fight starts, and I'm still trying to, what other evidence in this record do you point to establish, the reckless disregard, ill will, spite?
Well, first I would note that the fight did not start the very moment that they got outside the back door of the bar. There was a period of time after they got outside that defendant and his brother are arguing with Mr. Torres. Mr. Campos testified to that. Brian Brown, another employee, testified to that. And importantly, the brothers kept trying to get back into the bar, and Torres was the one who was blocking the door, keeping them from getting back in. And that was making them angry at him. And the argument continued. Eric testified at the motion to suppress hearing, agreed that they got into a heated discussion with Mr. Torres. There was testimony from Jose Campos that the defendant and his brother were mocking Mr. Torres, saying things to the effect, mocking his job, basically. "Oh, you only get paid $8 an hour to do this. Who do you think you are? What's your name? Oh, I'll remember that." And trying to belittle.
This certainly doesn't fit into the model, if you will, of a second-degree murder case. This is, at best for the state, kind of at the border.
Well, I disagree, because I think there was a couple of minutes there where the animosity towards Torres is ramping up and ramping up and ramping up, because Torres is the one who's not letting the defendant back in the bar, and he's angry. He doesn't feel like he should have been kicked out. He testified to that. It wasn't fair. He wasn't doing anything wrong. Who are they to kick him out, especially out the back door? And Torres is the one standing between him and going back in. And then the belittling of him. You don't have to have had several hours or weeks or months relationship for that ill will and spite to build up. And then immediately before the fight, here's Mr. Torres arguing with Eric, who...
Do you have another 20-minute case that you can share with us? That's basically what this is, 20-minute relationship. I understand if it was Chris Fuller, the guy that they were barred from being around, if he was out there in the fight and they stabbed him, maybe you've got that relationship. But I mean, really, do you have another 15 or 20 or 30-minute or hour case even where you have the ill will and hatred?
Well,
usually it's a longer-term relationship.
Or a situation where you're shooting into a crowd.
Right.
Something of that nature.
Well, again, Your Honor, I would argue that there isn't a time frame that the state needs to meet. No, I honestly cannot point to a case specifically with that time frame. But I would note Rasley, which I cited in my brief, which different, admittedly, in that there was a prior relationship. It was a husband and wife situation. And they had a tumultuous relationship leading up to her shooting her husband. But on the date in question, they argued because she found out that he had been having an affair. He leaves, he comes back to the house, he's advancing towards her, she shoots and kills him. The defense, of course, is self-defense. He's battered me in the past, but there had also been this other evidence that she had just found out that he had an affair. So the facts were equally susceptible to being interpreted by the jury as she shot him because she was angry and jealous, as she shot him in self-defense. And I would say that that's the situation here. His version is, I stabbed Mr. Torres in, as you characterized it, Your Honor, imperfect self-defense, but the facts taken in the light most favorable to the state are just as well interpreted, just equally interpretable as he was angry because Torres is arguing face-to-face with his supposedly vulnerable brother. He's drunk. Torres won't let him back in the bar. They're belittling him, making fun of his job, asking for his name. So taken in the light most favorable to the state, a reasonable jury could find second-degree murder here, did, even though that they were instructed on manslaughter, obviously. And the issue is whether the judge was proper in denying the motion for judgment of acquittal. And yes, because there were facts to support the state's position, and it was properly left to the jury.
I'd like just very briefly for you to discuss the knife and the determination that it wasn't a common pocket knife. Is that because of the spring aspect of the knife?
Well, Your Honor, the knife was brought in at the motion to dismiss hearing through the defendant. Actually, it was during the cross-examination of the defendant that the state introduced it. The defendant denies that there is a spring in the knife. The state didn't present any evidence to the contrary. The trial court relied on a case out of this court, actually, I believe, called KH. Yes, it is out of this court. KH, the knife was described as a folding type switchblade. So I think most people think of a switchblade generally as coming straight out of the knife.
No, that's a stiletto.
Oh, I'm sorry. Well, there you go.
Blade you would think of as you press a button and the blade opens to a locked position.
Well, here the trial court found that it was similar.
I'm from Chicago originally.
Oh, I see. I'm from Canada, so I don't have as much knowledge about that. But I think that what the trial court was relying on here is the fact that you could easily, and Appellant agreed to this during cross-examination, push a little button or lever with your finger, a quick flick of the wrist, and the knife locks into an open position. And that was the knife in KH, even though it sounds like the knife in KH did have a spring. I'm not sure that the spring or lack of spring is what's determinative. It doesn't specifically discuss it, but I would assume that the ease in which the knife opens is why it's relevant whether something is a switchblade or not a switchblade.
What's our standard of review on that? Is that novo, discretion, use of discretion?
Well, it's relevant because of the denial of the standard ground motion. So yes, the standard of review on that is de novo. I would point out that the actual knife was entered into evidence. The judge had the opportunity to view the knife himself. There are cases on which he could, and
Record on appeal here in our court.
I'm sorry, Your Honor.
The knife is here. It's part of the record on appeal.
You have the actual knife? Oh, well, there you go. So Your Honors could look at it too. I've seen photographs. I haven't obviously been able to manipulate it and see how it works, but the judge had competent evidence on which he could rely to find that it was comparable to the knife in KH. There's another case called JDLR that they noted a notched combat-style grip, which seems to be similar to the knife here. FR locking blade. But, Your Honors, whether you believe or disagree with the trial court as to whether the knife is in fact not a common pocket knife is kind of irrelevant because ultimately the use of force was not reasonable. So even if the trial court erred in finding that this was not a common pocket knife and therefore he could not assert immunity under 776.013, the court still properly held that the use of force was excessive and denied the motion.
You've exhausted your time, and I think in my 8 years on this court, that's the first time I've ever said that to an assistant.
I'm a little surprised too. Thanks for letting me set a record.
think how long we could go, Judge, if we talked about all the issues, but the couple I want to deal with, number one, Judge Cohen, your comment at the beginning of her argument about what evidence in the record to support a self-defense, besides cross-examination. The state presented Craig Sandhaus' testimony to the police where he said he did it in self-defense. It presented his testimony at the Stand Your Ground hearing where he said it was in self-defense. There's no issue here about whether there was sufficient evidence for the defense to get an instruction on self-defense. Second,
How do you respond to the state's argument on the level of malice or ill will between the parties? You know, apparently there's it's hard to tell how long, but these guys get tossed out. They're in the back, upset, apparently mocking the guy about his job, and, they're angry and they want to see a manager, and they want to get back in, and he's keeping them out. Does any of that enter into the length of time that's appropriate to determine whether there was time to generate this level of ill will and malice?
it does, because just like in the case that they talk about Rasley, which is a husband and wife and therefore a long-term relationship, you have to look at the relationship. Here's a relationship started that evening, and we don't know the exact length of time.
Well, but certainly you can have second degree without any relationship in the example.
Oh, absolutely, Judge, no question. All right, just first degree as a lesser first degree, a lot of ways you can get second degree. But what I'm suggesting here is that in this case, you have Craig asking for Mr. Traybold to go get a manager, and he does. At that point in time, there's jawing back and forth between Eric and Mr. Torres, but there's no real level of argument going on. Traybold goes to get the manager, and during that time frame, Mr. Torres and Eric escalate, and you get the incident that we end up with. So I submit that...
Well, the fist fight, or the fight, only lasted 20 or 25 seconds.
Absolutely.
But the jawing back and forth and the heat level increased over a period of some minutes, didn't it?
Well, but there's not a lot of discussion about jawing back and forth. The Sandhauses were not happy about being kept outside, but the bar people were offering drinks and stay out here and have a drink, so I don't know. There's no real issue. There's no evidence that they were saying we're going to kick your butt, or we're going to use force, or we're going to, we hate you for doing this, or I mean, there's nothing like that. These are people outside a bar, like Judge Cohen said, at 2 o'clock in the morning. They're not happy they're out there. But there's no level of ill will and hatred to reach a second-degree murder. Thank you, judges.
Thank you.